Well, I mean, in case you were wondering, the TikTok psychic shenanigans, they're still ongoing, and it gets more and more insane for every month that goes by. As the court case is still ongoing because Ashley, the TikTok psychic, keeps filing counterclaims. So it seems like it's just delaying the inevitable, but here we are. If you're lost, yeah, we're still talking about the TikTok psychic who used the tragedy of the 4 Idaho students for her own gain on TikTok. And she did all of this by making up an elaborate story about an innocent professor from Idaho claiming that she was having a romantic relationship with one of the victims, and therefore she was behind all of this. The only problem here is the professor has never met the victims, and the only proof the TikTok psychic has is tarot cards, her vision, and her intuition. So yeah, she essentially just pulled it out of her. But the most surprising thing of all this was when Rebecca Schofield, the innocent professor in all of this, sent her a cease and desist. Her reaction was to laugh at it.
I'm about to put this demand letter Rebecca Schofield attorney sent me by the tissue so I can wipe my with it.
And she proceeded to make an absolute mockery of the cease and desist. And I guess in her own delusional mind, that made her think that her tarot cards were really onto something now. The only thing that they're onto is bankrupting her. But over the last year, we've seen the TikTok psychic Ashley go through a whole bunch of different emotions in regards to this case. First, it was arrogance, but then when the lawsuit became real, she doubled down on her arrogance.
I have physical evidence against Rebecca Schofield that validates everything that I've said about her, but I can't speak on it now because it has to wait for court. So hopefully court doesn't take too long.
This is when she was excited to prove that Rebecca Schofield is behind all of this. But then suddenly, I guess, reality set in for her, and then she started freaking out, saying that this lawsuit should have never happened in the first place. It was an improper venue, and so on and so on. Then she didn't even respond in time, and everything just turned into a massive mess. But it now seems like she's filed a bunch of counterclaims, 11 to be exact. And I do have to give a quick shout out to Madcaster for sending me all these documents, so special thank you to this man. But here's Rebecca Schofield's lawyer's motion to dismiss Ashley's counterclaims. Defendant Ashley Gilliard has filed 11 frivolous counterclaims alleging the plaintiff Rebecca Schofield had an inappropriate affair with a student, ordered that of 4 students, and conspired with her attorneys to sue Gilliard for defamation to evade suspicion, obstruct justice, and avoid criminal investigation. In support of her claims, Gilliard said that her spiritual research into all of the at the University of Idaho intuitively led to the University of Idaho History Department, so she then spiritually inquired into each person listed on the history. What? So she then spiritually inquired into each person listed on the History Department's webpage, and her insight for Rebecca Schofield revealed that she was in a relationship with Kaylee that broke up, and she initiated them, planned them, and hired help to carry the plan out. In other words, Gilliard made up the story. So she is ruining her own life because she went onto the history department of this school and she just had the intuition to say that, oh, this professor, this random innocent professor is behind all of this. Gilliard's claims all fail because they rely on implausible and factually deficient allegations. The claims also fail to properly allege the pertinent legal elements. Even as a pro se litigant, Gilliard should not be allowed to use this court as a platform to make frivolous allegations to continue her shameless self-promotion at the expense of Professor Schofield's reputation and peace of mind and the victim's memories. The court should dismiss all Gilliard's counterclaims under Federal Rule of Civil Procedure or its inherent power and exercise the inherent power to reward Professor Schofield her attorney's fees. Unfortunately, this is probably going to be the most sane statement that we're going to read today. One of them, at least. Because, naturally, our TikTok psychic Ashley, she responded to this, and she did so in a 20-page document. So, I mean, like, we might be, we'll be skipping around here, most likely. Introduction comes now. Counterclaimant Ashley Gilliard in opposition to the counter-defendant Rebecca Schofield's motion to dismiss counterclaims. Pursuant to Campbell versus Wells Fargo Bank, it is standard that specifically when deciding Federal Rule of Civil Procedure motions, the court assumes all factual allegations contained in the complaint to be true, giving the claimant, to include counterclaimant Ashley Gilliard, the full benefit of the doubt. Counterclaimant Ashley Gilliard asserts that the statement she made in the factual allegations of the countercomplaint are substantially true. Given the full benefit of the doubt, the 11 counterclaims Ashley Gilliard filed are merited. State's claim for relief are worthy of adjudication. And of course, here she comes just absolutely like doubling down. This is her doubling down for like the 70th time. Rebecca Schofield planned, initiated, ordered, and executed the blank of 4 University of Idaho students who were in Moscow, Idaho on November 13, 2022. Rebecca Schofield went undetected by by Moscow Police Department, Idaho State Police, and FBI detectives who were assigned to the case. But the TikTok psychic, she picked up on this. All these law enforcement agencies, they missed it, but Ashley Gilliard, she knew because she has tarot cards and intuition. Oh man. And she just flat out says it as well. On November 24th, 2022, Ashley Gilliard used her psychic abilities, spiritual acuity, and investigative skills to uncover the motive and details that led to the students. She posted her findings on social media and reported it to the FBI tip line. To stop Ashley Gilliard's information from being taken seriously and to silence her, Rebecca Schofield and her attorneys, Wendy and Elijah Corey, filed a lawsuit against Ashley Gilliard with 2 frivolous claims for defamation. Rebecca Schofield initiated the lawsuit with full knowledge that she was responsible for the 4 students with the intent to harass, embarrass, humiliate, and discredit Ashley Gilliard. Oh man. The attorneys worked concertedly on the lawsuit of Schofield versus Gilliard. Together, they failed to exercise reasonable due diligence to ensure the truth of the claims against Ashley Gilliard before filing under oath that the claims are true. This must be one insane trip for these lawyers to have to work on this case and have to deal with her. Instead, they conspired with Rebecca Schofield to discriminate against Ashley Gilliard for her spiritual beliefs and practices. They also harassed, embarrassed, humiliated, and discredited Ashley Gilliard and attempted to defraud her out of millions of dollars under the color of the law, attorney, and judicial immunity. The result of the tactical strategy to destroy Ashley Gilliard to prevent Rebecca Schofield from suspicion and investigation of quadruple they collectively violated a multitude of Ashley Gilliard's rights that resulted in at least 11 merited claims for relief. Oh man. Defendant Ashley Gilliard has an unbreakable faith in her spirit, spiritual acuity, and spiritual practice. She has strongly held that she believes in everything that she said about Rebecca Schofield is substantially true, not once faltering despite circumstances. For that reason, the plaintiff's defamation claims does not meet the required elements. Counter-defendant's tactics so far is for the court to discriminate against spiritual practices and belief and deem it is implausible to meet the or reasonably should have known it was false element required for a libel claim. Their tactic is unconstitutional as it requires an entire spiritual practice as defined in the Title VII of the Civil Rights Act of 1964 and protected by the First Amendment of the U.S. Constitution to be determined as unreasonably by the court. They will not win this argument. For those reasons, counterclaim Ashley Gilliard's 6th and 7th counterclaims for relief of malicious prosecution should not be dismissed. Ashley Gilliard decided to litigate her own defense and counterclaims. She has not intended to increase the cost of litigation for Rebecca Schofield nor for herself. She is simply standing her ground within the parameters of the law. For these reasons, and for those reasons stated in the entire response, Ashley Gilliard requests the court to deny the counter-defendant's request for attorney's fees. Conclusion. Counterclaimant Ashley Gilliard requests that the court deny the counter-defendant's entire motion to dismiss and deny the request to award Rebecca Schofield her attorney's fees. Oh boy. And this is where stuff gets pretty wacky because Ashley also requested discovery, which is interesting to say the least. So what discovery did she request? Well, apparently Ashley thinks that discovery is necessary on the following subjects issues. For plaintiff, which is Rebecca, so she wants all of this from Rebecca's. Defendant's false statements about the plaintiff's relationship with Kaylee and involvement with the of those. Oh man. The falsity of the defendant's statements, defendant's awareness of the falsity of her statements, the damages plaintiff incurred because of the defendant's false statements, for defense and counterclaims, the substantial truth of Ashley Gilliard's statements about Rebecca Schofield's role in the you-know-what, the substantial truth of Ashley Gilliard's statements about Rebecca Schofield's relationship with Kaylee, the attorney's lack of due diligence before filing the civil complaint, and the failure to abide by Rule 11. The full details of the press release that defamed Ashley Gilliard and all involved, who, what, when, where, why, and any payments related to it. All communication tools used by Rebecca Schofield personally and professionally to write and communicate with co-conspirators and collaborators in the creative arts, manuscript, and book writing process to resolve the issue of her involvement in the planning of the you-know-what of the 4 university students. All social media accounts created by Rebecca Schofield and her IP address on TikTok and Facebook to establish her connection with the creation of accounts on social media to continuously harass Ashley Gilliard. She's just hitting her with the reverse Uno card here. I didn't harass you, you harassed me. All communications and financial accounts Rebecca Schofield used at the University of Idaho to establish a communicative and financial connection to the 4 university students. Rebecca Schofield's personal and business financial records to establish a financial connection to the 4 university students. Obviously, she's never gonna get these, but like, what if she actually got all this discovery? She spent like a year to go through it and she couldn't find anything. Will she actually admit defeat then? Or like, will she just claim she didn't receive everything? In what universe would she need all of this? Like, why? And also, who does she think she is with requesting all this information? Like, who is she, the government? Like, what is going on here? Rebecca Schofield's cell phone, tablet, computer, electronics, device records to establish a connection to Kaylee and co-conspirators of the you-know-what. Yeah. Oh my goodness. Communications, documents, emails, personal and business phone records between Rebecca Schofield and Wendy and so on and so on. Bruh. Pre and post filing of the lawsuits to establish a personal prior relationship between the two prior to the filing of the lawsuit. Schofield versus Gilliard. All work products between Rebecca Schofield and the attorneys and so on. This is to establish the lack of due diligence and adherence to the FRCP Rule 11 before the filing of the frivolous claims against Ashley Gilliard. Travel documents, arrangements, modes of transportation, rental cars, hotels, and lodging for Rebecca Schofield and immediate family members for the months of October and November of 2022 to establish the substantial truth of Ashley Gilliard's statements regarding Rebecca Schofield's role in the you-know-what. Oh man. Rebecca Schofield's alibi for the day prior to, the day of, the night of, and the next day following the discovery boundaries. Limits. The parties agree to limit the number of discovery tools as follows. No limits. No. But the judge made a memorandum after all of these shenanigans. So here's the judge memorandum here, which actually kind of puts Ashley a little bit in place here. So it starts off with this case arises out of the tragedy that happened on November 2022. The plaintiff, Rebecca Schofield, is a professor of the University of Idaho. She alleges that she never met the students and was not involved with their in any way. Notwithstanding, plaintiff alleges that defendant Ashley Gilliard posted over 100 sensational TikTok videos falsely claiming that she had an inappropriate romantic affair with one of the victims and then ordered to prevent the affair from coming to light. In turn, plaintiff initiated this action on December 21st, 2022, asserting 2 defamation claims against defendant. One is premised upon false statements regarding plaintiff's involvement with the themselves. The other premised on a false statement regarding plaintiff's romantic relationship with one of the victims. Defendant, representing herself, did not immediately respond to plaintiff's complaint by January 17, 2023 deadline. A defendant must serve an answer within 21 days of being served with a summons and complaint. As a result, plaintiff moved for an entry of default on January 19. A clerk's entry of default was then entered and mailed to the defendant on January 27. On February 16, 2023, defendant moved to set aside an entry of default. Plaintiff responded the next day, opposing defendant's efforts to set aside the entry of default, and filing a motion for default judgment pursuant to Rule. On April 24, 2023, the parties consented to the undersigned jurisdiction. Thereafter, on April 26, 2023, the court granted defendant's motion to set aside entry of default, denied plaintiff's motion for default judgment as a moot, and ordered defendants to respond to the plaintiff's complaint within 21 days. On May 16, 2023, defendant filed her answer, affirmative defenses, and counterclaims to the complaint, answer and counterclaims. With her answer and counterclaims, defendant denies that she defamed plaintiff because the accusations she made against plaintiff and defendant's TikTok videos are substantially true. Defendant maintains that she used her spiritual brain intuition, spiritual practice, and investigative skills to uncover the truth regarding of the University of Students, and published her findings on the TikTok social media platform. Relevant here, defendant also affirmably asserts 11 counterclaims against both plaintiff and her legal counsel. Defendant's counterclaims rely on 2 premises. Plaintiffs initiated, planned, and executed the of the 4 university students to cover up an affair she had with one of the victims. And I just want to comment real quick and say I keep laughing there, not because of the tragedy, but because of how ridiculous these statements from Ashley are. And this is how she decides to spend her year. But continuing, plaintiffs sought to evade suspicion for these by conspiring with her counsel to file a frivolous complaint with falsified factual allegations that supported the defamation claims against the defendant and deprived defendant of her constitutional rights. Defendant further asserts that conspiracy between the plaintiff and her counsel extended beyond the mere filing of plaintiff's complaint. It also includes plaintiff's counsel's defamatory statements to the media about plaintiff's underlying lawsuit against the defendant. Defendant alleges that owning up to plaintiff and her counsel's conduct in these interrelated respects, she has been presented in false light, harassed, including so on and so on, deprived of her good reputation, and prevented from pursuing her livelihood. What do you think the professor got from this, Ashley? I guess in response to that, she threw in the first counterclaim, which was defamation. Second counterclaim, defamation. Third counterclaim, obstructing justice. Fourth counterclaim, action for neglect to prevent. 42, conspiracy to interfere with the rights of due process of freedom of speech. Fifth counterclaim, civil action for deprivation of rights. Sixth counterclaim, malicious prosecution. Seventh counterclaim, malicious prosecution. Eighth counterclaim, obstructing justice. Ninth counterclaim, action for neglect to prevent. Conspiracy to interfere with the right of due process that's guaranteed by the 14th Amendment of the U.S. Constitution. 10th counterclaim, intentional infliction of emotional distress, frivolous claim. 11th counterclaim, intentional infliction of emotional distress, multinational press release and news coverage, defaming Ashley Gillard. Plaintiff moves to dismiss each of these claims against her, arguing that they are not only factually implausible but legally deficient. Further, plaintiff moves to quash the summons of her counsel, arguing that their issuance is procedurally improper. Each of these motions is ripe for the court's consideration and resolved below. Certain of defendant's counterclaims reflect on these beliefs. First, second, third, fourth, fifth, eighth, and ninth counterclaims, alongside related counterclaims for malicious prosecution and intentional infliction of emotional distress. Sixth, seventh, 10th, and 11th counterclaims. Together, these counterclaims presume and depend upon an alternate version of events surrounding the of so on. Namely, the plaintiff orchestrated everything and then colluded with her counsel to bring this action against defendant to silence her clairvoyant insight into the true extent of plaintiff's involvement. The problem with this theory, however, is that there's no objective basis to believe the plaintiff did the things that defendant publicly and repeatedly claims she did. Defendant insists that her intuitive abilities, spiritual acuity, and investigative skills into these led her to the plaintiff. Specifically, she claims that during her spiritual research, she was intuitively led to the University of Idaho History Department and spiritually inquired into each person listed on the History Department's webpage, seeking their role in the As defendant describes it, the insight into the plaintiff in particular revealed that she was in a relationship with one of the victims that broke up, that she initiated this, planned everything, and hired to help carry the plan out. The results of defendant's spiritual investigation represent the only support for defendant's belief that plaintiff masterminded all this. Correspondingly, the only justification for defendant's counterclaims against her. Significantly, only defendant has these opinions about plaintiff. The court is unaware of similar claims from any other sources or the existence of any independent evidence remotely suggesting the same. When pressed for corroboration during oral argument, defendant merely responded that she believed her allegations about plaintiff were true and that with discovery, she can find evidence that bears this out. Oh, so that's why she wanted that discovery we covered earlier. Defendant also claimed that plaintiff, as a professor in the University of Idaho, possibly knew the deceased students and was involved in there. Without more, these explanations do not support a plausible claim for relief under, To begin, defendant cannot use discovery as a fishing expedition to find facts that might validate her counterclaims. This ready, aim, fire approach is not permanent under the federal rules of civil procedure. Moreover, on a motion to dismiss, courts genuinely may not consider materials, including discovery, other than complainant's allegations and documents made part of that complaint. In short, the pleading requirements does not provide a key to unlock all the doors of discovery for a plaintiff armed with nothing more than conclusions. Again, a complaint must be plausible on its its face. More to the point, defendant does not present to the court in either of her answer and counterclaims or her response to plaintiff's motion to dismiss a factual account that would allow the court to interfere with the existence of plausible claim against plaintiff. Instead, based solely on her claimed ability to psychically divine the truth, defendants makes extraordinary allegations about how plaintiff orchestrated you know what to cover up a secret romantic relationship with one of the victims. These claims are not only conclusory and unverifiable, but arguably so outrageous as to be clearly baseless and thus implausible. Because the predicate components to the defendant's counterclaims against plaintiff lack any basis in fact, those counterclaims should not proceed. Additionally, defendant attributes the conduct of plaintiff's counsel to plaintiffs based upon a perceived conspiracy between them, but she offers no basis for concerted action. She simply assumes that existence throughout her answer and counterclaims when alleging that together plaintiff and her counsel conspired to harm her. Reflexively lumping plaintiff and her counsel together without distinguishing their conduct in any way fails to satisfy Rule 8, Dana versus 12. This is particularly problematic when under Idaho law, claims of conspiracy must be pled with specificity. There's no other way I would like to spend my time getting better from COVID than reading through some absolute buffoonery in a legal document. I can't believe this is real still. I feel like the pink sauce lady and the TikTok psychic here is having a stupid off in 2023. I can't really tell who's winning. It's really hard. In this case, I think the TikTok psychic is actually winning this because this is just a new level of buffoonery. This is some really silly business to be goofing around this much in the court of law. At bottom, the court struggles to accept the defendant's allegations as creating factually plausible counterclaims against plaintiff. This alone would justify granting plaintiff's motion to dismiss. But defendant's counterclaims are also legally deficient and therefore separate subject to dismissal for failing to state a claim upon which relief can be granted. Oh, so this is one of those moments where she's representing herself and she's coming across as not the sharpest tool in the shed here. Oh boy. I don't know. It seems like we have lawyers for a reason, and this is one of the reasons why. In Idaho, only statements of opinion may enjoy constitutional protection. False statements of fact are actionable. Plaintiff's defamation claims against defendant implicate the distinction, but they do not give rise to an affirmative counterclaim. Nor does defendant believe that plaintiff brought her claims in the wrong venue. Rather than bring a claim, defendant should have challenged plaintiff's complaint for improper venue in accordance to Rule 12b-3. But if we skip down to the order here of this memorandum, you have, based on the foregoing, it is hereby ordered that plaintiff's motion to dismiss defendant's counterclaims is granted in part and denied in parts as follows. Defendant's counterclaims against plaintiff are dismissed with prejudice. In this respect, plaintiff's motion to dismiss defendant's counterclaims is granted. An attorney's fees award against defendant is not warranted at this time. In this respect, plaintiff's motion to dismiss defendant's counterclaims is denied. Plaintiff's motion to quash summonses for the attorneys of the Schofields is granted because plaintiff's counsel is not a party to the action. Any consent deadline directed by plaintiff's counsel is inapplicable and hereby vacated. Consistent with paragraph 4 of the court's scheduling order, plaintiff's proposed discovery plan controls unless otherwise ordered. So that was the judge memorandum. This is just outrageous. And guess who responded to that? None other than our TikTok psychic with a freaking 17-page document. She has way too much free time. Way too much. Oh man. And of course, she keeps doubling down here as well. She follows up this response after what we just read, again by saying, Rebecca Schofield planned, initiated, ordered, and executed the you know what? Oh, man. And then, of course, painting herself as the hero here, she posted all of her findings on TikTok and in an FBI tip line, and so on and so on. So she's claiming here, judgment is a void judgment if court that rendered judgment lacked jurisdiction of the subject matter or of the parties or acted in a manner of inconsistent with the due process. And then she called out, I guess, Rebecca's side for falsely claiming damages equitable to $1.863 million for jeopardizing Rebecca Schofield's employment and advancement in the University of Idaho, limiting Schofield's ability to perform new studies and produce new work, and severe mental distress for worries that an unknown made-up person may take violent action. If she gets awarded $1.8 million. I have no clue how Ashley Gilliard's gonna come up with that. Then I guess it seems like she's like upset that the professor did a GoFundMe to raise money to go for this lawsuit. But the richest part of all this here is this is what Ashley wants out of this. She wants to dismiss the action due to lack of subject matter jurisdiction, dismiss the action due to lack of personal jurisdiction pursuant to Rule 12b-2, dismiss the action with prejudice due to failure to state a claim for relief pursuant to rule, set aside order document 49 pursuant to Rule 60b-4, and finally to award Ashley Gilliard all court-related fees and sanctions pursuant to Rule 11c in the amount of $1 million pursuant to B. Chambers v. NASCO. In what world does she get $1 million from this? In what world does any of this make sense? This doesn't make sense. This is the dumbest lawsuit I've ever seen in my life. I feel terrible for the professor. Anyone with 2 brain cells understands that she's innocent, but unfortunately, she still has to deal with all this BS. Because I guess this TikTok psychic will happily drag her name through the mud just for some attention on TikTok, and now she's lost her TikTok accounts because of all this, because it was targeted harassment. But she's not giving up the legal battle, that's for sure.